Thank you, Deputy President. Today I rise to speak on the Justice Legislation Amendment Bill 2022. This is yet another omnibus bill that brings about many changes in the realm of justice. I will state from the outset that the opposition will not be opposing this bill. Some of these amendments are simple changes to bring legislation up to date and to make it more inclusive. Others are reforms that will have a huge impact on the lives of Victorians. This bill will be particularly significant to all Victorians who have been through the adoption process or maybe adopted themselves. And I'd like to thank Dr. Buck for his contribution earlier, telling the Chamber about his lived experience. When you're able to speak to lived experience, it is certainly more impactful when speaking to bills that impact lives. Now, between the 1950s and the 1980s, childbirth was very different for many expectant mothers due to forced adoption practices. Unwed mothers were silenced when it came to speaking out about their hidden pregnancies, their treatment during birth, and the grief after having their children taken away. It is easy to reflect on these times as something we have moved forward from, but there are so many women and children who are still impacted and traumatised by what happened all those years ago, and understandably so. This bill amends the Births, Deaths and Marriages Registration Act 1996 to allow adopted persons to be issued an integrated birth certificate. An integrated birth certificate is one that lists both parents as well as the adoptive parents of the individual. This is one of the recommendations from the Forced Adoptions Inquiry of the Legislative Assembly Legal and Social Issues Committee. Many people told the committee how difficult it is to have multiple certificates containing different information and how hurtful it is to see their original certificate with a big red cancelled stamp through it. This amendment does not make it mandatory for a person to have both sets of parents on their birth certificate, but it gives them the option. This will allow adopted Victorians the choice to have their birth certificate reflect the story they want to tell, which is something we support. This bill also removes the ability of the department to adopt out a child in its care without the consent of the birth parents. Where a child has been taken into care due to the birth parents deserting, neglecting or ill-treating that child, the department will now need the consent of the birth parents before adopting a child out to another family. Some people would question why birth parents who have treated their child so awfully could stop that child being adopted out to a more loving family. There has been concerns put forward that birth parents who neglect their children may still have control over the future, and they should not. The wording of this clause means that birth parents will have the ability to prevent that child from joining a family willing to adopt and care for them. The opposition is not opposing this clause because we do not believe the government would want these children to suffer any further. The intent of the clause appears to attempt to strike a balance so that the trauma and the pain that comes from a child being adopted out is no longer repeated. One example might be if a child is taken into care because their parent has a drug problem and then that parent works extremely hard to rehabilitate themselves. There are situations where parents rehabilitate themselves and completely turn their lives around, and there are also situations where parents do not. The pain and trauma that comes with adoption is very real and lasts a lifetime. This clause intends to ensure children are not just adopted out while parents are making the changes they need to become responsible parents. It intends to treat adoption as a last resort. I can see what the government is attempting to do here. They are trying not to repeat the pains of the past. However, this needs to be monitored and appropriate guidelines developed. We must ensure birth parents do not use this mechanism to withhold consent to further their child abuse. The best interests of a child must always be at the forefront and centre of these decisions. The bill does a number of other things. It also gives the Secretary of the Department of Justice and Community Safety the ability to disclose adoption information to other organisations that require access, such as births, deaths and marriages, who need access for integrated certificates. There is some concern here, again, around the balance of rights. Obviously, adopted people have rights to find out information about their heritage, but their birth parents also have rights to privacy. I am of the view that this section probably should have had some further consideration, especially around the protection of privacy implications. Moving on, this bill, as I said, is an omnibus, and something else I want to refer to as well is this bill at clauses 9 to 24 amends the Charter of Human Rights and Responsibilities to use more gender-inclusive language. There are small changes, such as changing his to her to their. This will go a long way towards making Victorians feel included, which I support. I also note Mr Grimley's contribution and would agree with that. Ensuring language is inclusive is all well and good, however, not to the point of where political correctness has gone mad, where you can no longer refer to your parents as mum or dad when at school, but as rather as female identifying parent or male identifying parent, or changing the term breastfeeding to chest feeding. We need to always be respectful and inclusive with the language we use. It matters. However, making changes must be reasonable and balanced. I have outlined the numerous things that this bill does, but I am equally as concerned about the things it does not do. This is the third omnibus justice bill I have spoken on since becoming a member of this chamber in the last 5 months. We are seeing many little amendments grouped together, some more significant than others, but what we are not seeing is the government address the real issues in the justice system, such as the court backlogs and, as Dr Bark referred to earlier, within the youth justice system also. Victoria has the worst criminal case backlogs in the country. 11.3% of people wait for more than 2 years for a county court trial, while 30.5% wait more than a year for a magistrate's court civil claim. In New South Wales, it is just 3.7%. What did this government get so wrong? Our backlogs are worse than any other state in Australia, and we have been warned that it may take decades to get to the top of that. Yet we have still not seen a plan to actually address it. The stress of a court case hangs over a person's head for a long time. It can be quite disruptive to everyday life. The government is only dragging out this for Victorians. There are people out there who have been charged with something and are eagerly awaiting to clear their name. Many women are also being held in remand, waiting for their time as well to be heard. People who may very well be innocent. There are victims of crime also waiting to tell their story and have their pain recognised. And there are others waiting to be sentenced so they can get on with their lives. All Victorians deserve their day in court. It is one of our fundamental principles that we have rights to, and it has been denied for too long. I would urge the government to address the enormous court backlogs the next time they pull together a bill aimed at improving justice.